You might recognize the name Leslie Black. He pleaded guilty to a brutal attack on a homeless woman in Prince Albert back in 2014. She was so badly burned that her legs had to be amputated. Well, Black is facing a dangerous offender hearing this week. Our next guest says Saskatchewan uses that designation more than any other province. Barry Nychuk is a criminal defense lawyer in Regina, and he's in our Regina studio. Good morning.
Good morning.
First of all, take us through exactly what it is to be declared a dangerous offender. What does that designation mean?
Dangerous offender designation is a procedure set out in the criminal code that is intended to be a designation for the worst of the worst, for serious violent offenses, sexual offenses, where the primary goal in sentencing is no longer a consideration for reformation, rehabilitation. It becomes simply removing this individual from society as a preemptive strike to protect society in the future because this person is not likely to be rehabilitated.
And there were some changes back in 2008. What changed then?
There were significant changes in 2008. The government of the day, the conservative government under Stephen Harper, they made it easier and basically changed some of the onuses and changed some of the standards set out in obtaining a dangerous offender designation. Furthermore, they created a new way to become a dangerous offender, the 3 strikes you're out rule, adopting legislation not dissimilar from that in the United States. What it says is that if you commit certain crimes, which are serious crimes, primary designated offenses, and received prison terms in excess of 2 years, if you committed another offense that was a primary designated offense, received another sentence of 2 years, it is presumed that you are dangerous. Your third strike.
What kinds of crimes are we talking about there?
Primary designated offenses are a lot of sexual offenses, sex assault, sexual interference, attempted murder, aggravated assault. These are serious offenses.
Yeah, so this really broadened the scope of it, hey, part of the get tough on crime approach of the Harper government?
Absolutely. What happened under the legislation tackling a Violent Criminals Act, I think is what it was called in 2008, broadened the net of those people that might be caught as dangerous offenders, certainly, but it was more than just broadening the net. It created a new category of dangerous offender and furthermore changed the onuses and some of the wording in the dangerous offender legislation, making it a much easier hurdle.
Is there any push to go back to what it was before?
Not in Canada that I'm aware of.
No, people are happy with the way it sits right now.
I don't know. I can't speak for everybody, but I don't see a lot of push. I know in America, there is certainly some now pushback because the prisons became overpopulated. Certainly in California, we know that many, many people had to be released from prisons just because they'd become overpopulated with people on the 3 strikes, dangerous. What
are the chances once you're declared a dangerous offender of getting out ever?
If you are given an indeterminate sentence, the chances and designated as a dangerous offender, the chances of you ever seeing freedom again are very, very slight. We just looked at the 2014 statistics. In the 2014 statistics of corrections and conditional release statistical overview, there were 622 dangerous offenders.
In Canada?
Yeah.
Okay.
36 that were designated to be dangerous and given an indeterminate sentence. Only 36 were ever released for any period of time, so about 5%.
Is there a review process?
There is a review process. However, it's very difficult. You have a review process. You can apply to the parole board after 7 years and every 2 years thereafter. The difficulty in doing that, you've already had a court determine that you're dangerous, and determine that it's too high risk to have you in society. So very few people are successful. Even though there's a 5% people that ultimately can get released, you have to understand many of the cases or situations where these people are released, they're often palliative care, they're cancer, they have weeks or months to live. So they fill the statistics a bit, but still even at that, it's a very, very small percentage that ever get released.
You've talked about how Saskatchewan has a high rate of this designation, of using this designation. How much higher than the rest of the country? Can you put that in context?
Absolutely. Attended a national conference in 2013. At that time, we studied the statistics from 2012. They haven't changed much. I just looked at some of the statistics this morning. But at that time, Saskatchewan had 40 dangerous offenders. There were 486 in Canada. So approximately 1 in 12 dangerous offenders in Canada reside in Saskatchewan. at that time, Saskatchewan had 1.1 million of the 36 million people living in Canada. So
Wow.
1 out of 36. So we have 3 times the national average of people serving as dangerous offenders in Saskatchewan.
Why do you think that might be?
Again, the decision to bring an application for a dangerous offender is a discretionary decision. It's given to our Crown Prosecutor's Office or Attorney General. They make that decision. Obviously, they've decided to use that tool in the toolbox more often than other provinces. I'm not saying it's not justified. They may have rationales and reasons for that. Certainly in the cases that I'm familiar with, they have been successful, acknowledging, however, that this is not a difficult hurdle to overcome.
What's your take on some psychiatrists have talked about it being overused and in some cases people have mental illness and we're warehousing people with mental illness, we're warehousing people with fetal alcohol spectrum disorder. What's your take on that?
I can only speak from my cases that I'm familiar with, but I can tell you that only 2 cases I've had in the last 10 years both involve those 2 issues. One was a FASD situation. One was a mental illness issue arising out of
diagnosed mental illness?
Yes, arising out of drug abuse. So crystal meth addiction and abuse resulting in significant difficulties and cognitive problems in his brain. And the other situation was an FASD situation where that individual became very, very violent when drunk or intoxicated and had committed these offenses. So I don't know what those stats are, but for my cases,
They were both declared dangerous offenders?
in those situations, the Crown had given me an indication they would be seeking that designation. In the one situation, they ended up staying the charges. In the other one, we worked out a definitive term of incarceration. So the way to avoid a dangerous offender is be found not guilty or get the or have the charges stayed. So we never had to get to the dangerous offender application.
Yeah.
But those people had already committed violent crimes that, if convicted of another offense, certainly would be the kind of people that would be sued.
Under the whole 3 strikes thing.
Absolutely,
Yeah.
the 3rd strike.
All right. Thanks so much for coming in.
Thank you.